we'll be speaking with them today as well, but it's very important that we hear from you and your perspective, how much cooperation you're getting, how much they are being responsive and open to your attempts to remind of best practices, even though they're not mandated by law.
Thank you.
Thanks.
Investigators versus. That's true. But Mr. Gomez, in looking at the overall kind of effectiveness of CPEI, what's your impression of that? Do you feel that it has been effective? Or do you think it may be time to kind of step back and relook at, reevaluate DCA's enforcement initiatives and how they work?
The CPI is working. When you look at 2010 and prior, there were no metrics or no standardization of what complaint intake was. There was no transparency other than our annual report that showed cumulative, the end of year, if you will, report, but there wasn't any quarterly report. There wasn't even actually any competition, if you will, between the healing arts boards when they each see each other's numbers to, what are we doing differently than they're doing? The other thing is that transparency is so important, not only to the legislature and to the public, but also internally for, our executive office to manage and monitor what direction they're going and why. Is it really vacancies or is it training? Is it, the case acceptance model that is not being followed for purposes of looking at workflow? I think it's a variety of things, but having said that, CPI is working. This is no longer a half-empty glass. This is 3/4 full, and we're going down that direction. We're making incremental and progressive moves to make things a lot better through our training consortium and our outreach programs with the Division of Investigation staff to the enforcement managers.
Mr. Chairman,
yes,
what my colleague said is absolutely correct, regarding the metrics, use of the metrics, and the vision of CPI and how it is just as, if not more important, where we are now. However, we're developing the means to completely revamp it using data, what metrics actually mean to each of the boards, and to make sure those metrics are meaningful and something that not only we can defend, but is based in fact. So, as we do that, we'll keep this body informed of where we are through that process.
Very good, thank you.
And Chairman Hill, if I may interject, yes, is that we have a 5-year track record now. We have to look at the targets of whether they're attainable, what the measurements really mean, but now we have a track record. I think that's what we're looking at to assess and analyze in terms of what we have accomplished, what we have not accomplished, and making sure that our goals are attainable.
Very good, thank you. I have one final question. We've heard testimony, at least last week, that at least one of DCA's boards was working with the collaboratively with the federal immigration authorities in the context of conducting certain sting operations within that board. What can you tell us about that practice?
Chairman Hill, the mission of the department is to protect the consumers, and in many cases, our investigations and our operations will require us, in many cases, to participate and work with federal agencies. In terms of the Drug Enforcement Agency, I can tell you that the department and our sworn personnel have numerous arrests and convictions under federal law for money laundering and overprescription of pharmaceuticals throughout the state and across state lines. So we have to work with the feds and those case types. What we don't do in this department, and it's not our mission, is we're part of an immigration effort. We don't check, and I'm going to assume that we're talking about CSLB, which when we found out, and the department found out that there was that kind of undercover or sting operation occurring, it was incumbent upon our executive office to go forward and inform the board. That is not our mission. To the extent that they're in control of the operation, that's not our mission to include immigration and naturalization into our unlicensed activity stings.
Last week in the testimony that was provided by CSLB, they indicated that when they were conducting their sting operation for unlicensed contractors, as part of that sting, they needed three law enforcement officers who could carry firearms, and that in securing that, they were basically given the three individuals that, or these are three individuals who are available to provide that security in those sting operations. It was indicated that they did not, at least the impression that they were left was that they did not intentionally request an ICE or an immigration officer to accompany them in that sting operation. Do you have anything to, or is your belief that it occurred different than that? Did they initially request an immigration officer to go with them?
I'm not sure on the clarity of that because I've received two different situations, and I don't know if they're the same situation when that was occurring, but I want to remind...
Either one, did it happen in that case?
It did in one.
It did in one that they requested an immigration officer.
But I want to remind the committee that, you know, my enforcement efforts with the boards and my communications with them has always been that it must be case relevant. It must be case relevant to the mission. It must be case relevant to, in the case you're talking about, armed security. I want to remind the committee members that federal agents of the United States do not have arrest and detention powers over residents of California for violations of state law, unless that is in an MOU between the sheriff of that county and the federal agents. So the armed security, I would caution that we do things like that unless the authority to be there is for that purpose.
I see. Very good. Well, thank you very much, because that is contrary to what we heard, we were led to believe last week. No other questions? Then we will, Ms. Keneally. Good afternoon,
Good
I think.
afternoon,
Right
Senator.
at it.
My name
Welcome.
is Kate Keneally. As I said earlier, I'm the Chief Assistant Attorney General for the Civil Law Division in the Attorney General's office. Two of my sections, of the 9 sections that I am responsible for, work very closely with the Department of Consumer Affairs, boards, and other entities. The licensing section, which is headed by Linda Schneider, who's what we call a Senior Assistant Attorney General. She runs that section. And we also have a section called the Health Quality Enforcement section, which is run by Senior Assistant Gloria Castro. Licensing represents about 35 of the agencies within DCA in licensed discipline matters. About 9 of those are healing arts boards. Those boards constitute about 60% of the workload of the licensing section. HQE, Health Quality Enforcement, represents 12 healing arts boards, and the 2 that constitute most of its work are the Medical Board and the Board of Podiatric Medicine. Health Quality Enforcement engages in the vertical enforcement model, which is where our office works very closely with Mr. Gomez's investigators to work up cases. And then the licensing section, typically with its boards, does what we have referred to as a handoff model, where the investigators will work up the file independently and then hand it over to us for the licensed discipline enforcement actions. So licensing rarely participates in the investigatory phase. That's the primary distinction between the two. We have attorney-client relationships with each of our member boards. So we develop close relationships with the individual boards, the individual entities. We spend a lot of time with them. We have liaison deputies who are assigned to each of these boards, who get to know them very well and help advise them on their practices and support them in their efforts to obtain consistency with the CPEI goals. For our part, we closely monitor all of our cases. We do that through a system called ProLaw, which is a case management system. ProLaw is our legal file. And because we're lawyers, we track everything we do. And as you all know, lawyers bill by the hour, so we bill our clients by the hour, and so we have very detailed information within our case file on what we're doing with our cases, and we have case aging reports that we provide to our clients on a quarterly basis, where we give to each of the individual boards that we represent information on how the cases are doing. It helps us to look and see if the case has been sitting in one posture for too long a period of time, and then, or if the cases are moving along the kind of pace that we think is appropriate for the case. The challenge, I think, in looking at something like a performance measure for these kinds of things is there's a wide variation among the different kinds of cases that we have. Many cases are routine. We handle thousands of cases. So many of them are going to be routine, and they typically will move along at a fairly predictable pace, but a significant number of cases are complex. And cases may take a long time to resolve for reasons that have nothing to do with inefficiency. For example, a case against a medical doctor whose license is at stake that goes to OAH, where the doctor has counsel and hires several expert witnesses may take a long time to set. And so we do look at these things. We do classify cases and try to get a sense of whether or not a case is taking a long time because it's complex, or if we take a look at a case that may be taking longer than we want it to, and we think that the case is less complex, then we will take a closer look at it. Our supervisory structure within the office is the same for all of our various divisions and sections. We have deputy attorney generals assigned to cases, and they are supervised by supervisors, and those are ultimately overseen with each case by the senior assistant. So we have lots of data, we track it very closely, and if a case is moving slowly, our supervisors will get involved to help move it along. There are lots of things that are out of our control that have nothing, as I said, nothing to do with efficiency of any of our clients or any of our partners that we're working with. One of the things I think is important to keep in mind is that recently, for example, OAH has gotten a lot more staffing. And traditionally, there had been delays within OAH that I think we are seeing be reduced because OAH has been able to staff up. We also have a project with OAH called in San Diego, case stacking, where what we're trying to do is assign several cases to a particular day on the assumption that some cases are going to settle. And so we've been working with that project, but it's too new at this point for us to really measure its effectiveness in reducing the wait time for resolving a case. Because from our perspective, for the most part, excluding vertical enforcement, we step in when a DCA client hands us a case, and then we see it through till it's settled or comes to resolution at OAH. So the OAH process is very important to our ability to be effective. And I think the other thing that's very important to our ability to be effective is our staffing and the volume. The volume of cases that we've seen over the last 5 or 10 years has just about doubled, but our staffing hasn't. And so at a certain point, without adequate staffing, it's difficult for us to keep up. There's only so much we can do. For example, the average caseload for a licensing deputy is 60 cases. So one deputy will have at one time 60 cases that person typically is handling. We've kept up with the caseload pretty well, even with this increase, but there's a limit to what one person can do. And one of the things that we found is that it's difficult to get additional staffing, and sometimes we're reacting. Because we can't justify the need for staffing until we can show that we're not able to keep up with the work. And so we have more staff coming on. We did put in a BCP for licensing. We're getting some more positions, and so that is going to help, but it still won't bring us up to the staffing levels that we had, say, 5 or 10 years ago. So I think that that's a factor, and it's one that we can certainly address, I think, through more staffing. But it's a fluid situation. The other thing is improving settlement techniques is one thing that we've been working on with our individual agencies. One thing we did notice when we were tracking cases is that it sometimes took a while to get cases settled, and we realized that it was because of the dialogue that we had to engage in with the board and the executive officer at the settlement stage that sometimes took more time than we thought was appropriate. And one of the things that we are working with our clients to do is to get settlement ranges. Once we take a case and the case is filed, we get the pleading back from the agency, we're working on identifying settlement ranges right then so that if we are trying to get a case calendared and we're talking to the other side about settling it, we can try to settle it out early. So those are things that we're doing. It is, though, sometimes difficult because there are times where the licensee has an interest in delay. Not always, but sometimes they do. So that can make it very difficult because while we're vigorous prosecutors, there's also due process, and sometimes continuances happen and there's just nothing you can do about it when the other side says they need more time to prepare the case or it's not a convenient date. So, but we work very hard with those things, and I think we, in partnership with OEH, are shortening the times to get cases actually, on calendar so that we can get it either settled or set for a hearing and to get it resolved. I guess in conclusion, what I would say is we think that it's very important to have performance measurements. It's important for us to be able to tell how we're doing. But we do have to be careful when we look at an umbrella type of solution to the problems. We have to always remember that the individual boards have individual mandates and processes and missions. And so when we look at average numbers, we have to take them as guideposts, but perhaps, delve underneath them too, to be mindful that the individual boards, because of their different missions, are going to have different timing constraints that affect their ability to bring cases to resolution. Thank you.
And I appreciate your talking about and mentioning some of the issues that you're moving forward with to shorten the time frame a little bit in there. But in reading through all of the sunset reviews, I mean, they consistently pointed to the AG's office as the reason for the delay. You indicated staffing, and certainly some things court, and I can understand, especially dealing with the healing arts profession and some of the challenges with confidentiality and records, and those, it's a little more difficult. But do you think there are any realistic standards that the Attorney General's office could have or develop that could work within this system? Because I think, there are some milestones, some there's been certainly resistance, I believe, to setting performance standards, or at least trying to, you've indicated there are things that you can do, things in the works, you're doing this and that, but without actual performance measurements, next year we could be hearing, well, we tried this, it's working a little bit, or that, something specific that we can look to and that everyone can kind of point their finger to that's maybe workable. And I mean, is that possible at all or feasible?
Well, I think, we do provide for our individual client entities case aging reports every quarter. So they have a lot of data from us about how fast we're moving with cases.
But that tells them that it's taken 3 years, or it's 2.5 years, or it's 4 years. It doesn't say, God, our goal was, 14 months or 18 months, and we've exceeded that by this much, and
right.
We're working towards reducing it.
Right. And we certainly we do have some internal goals. There's several of them. I don't have all the numbers in front of me, but we have goals for, the time, from the time a case comes in to when we would get it reviewed. And then we have a goal from the time we get it reviewed to when, we want to get it filed. So we have, we do have overall, I guess, dates that we look at for cases. Those are all in the aging case reports. I do think the difficulty is because of the variations of the types of the cases, it's very hard to make that be a meaningful thing. But we certainly do generate a lot of data for our client agencies that contain that information.
Well, it's interesting because last year, when the legislature attempted to require certain performance measures that they be adopted by the AG, you indicated, I believe, that it would be too costly. So I didn't hear that as a reason today. So I guess what we're trying to find, and I'm actually going to ask everyone that, is there the ability for the 3 agencies or everyone to come together and try to find some form or some reasonable target dates in processing this information and the boards on these disciplinary cases so that we can have some idea that we can move it forward at a reasonable rate of time. And perhaps I'll ask you, Ms. Keneally, if that is possible, that everyone could sit down and look at the different types of cases that we're talking about from the different boards or bureaus and try to identify some opportunities there that we can shoot for in the future. Because I think without a goal, it's just going to wander as it has been.
I do think that, I mean, I feel that we do that with our individual boards already. I think certainly we could continue to do that. I think the issue with the statute, I don't have the draft statute in front of me, but the goal, you know, the reports that we generate are tailored to our handling of the cases in pro-law, and to some extent, we're bound by what pro-law can kind of give us, right? That's our program. So, but we can, you know, there's some things that we can do within that. And, you know, I do think that we have continued to have a dialogue. I think we certainly can continue to do that and to identify time periods. I just think that it's important to bear in mind that there is a lot of variation among the agencies. And so we want to be careful to not generate a lot of data and then have it maybe not serve the purpose we really wanted it to serve.